Good. If you're uncomfortable anywhere to answer any question, just make it say, no, I'll not answer the question. Make it very clear and we have
I will. You can be rest assured I will. Don't worry about that.
I noticed your daughter has logged on too, Leah.
Yeah, that's right. That's right.
She's obviously musically talented. She's got a guitar and
she's very talented. She sings, she composes her own music.
Oh, wow.
She has her own shows on Instagram.
Oh, wow.
So,
okay.
Yeah.
Hey, Ratan, that's the next one to get. Let's have a look at that. My granddaughter sings. Granddaughter Samara, she's very talented. So she's taken after her father, Sandeep Vyas. He's a performer. So
that's great. Both my children both my children compose. So their music is on Apple Music and things like that.
Oh, wow. Wow.
My son also.
Jangir also?
Yeah, he also composes. Different type of music to my daughter, but both of them compose and they have their own music.
Wonderful.
Different music from what the father listens to, but still music, yeah.
Okay. So what's your genre of music?
No, I've always loved Western classical. I mean, I listen to all types, but for me, that's my complete passion. I've been listening to it from the last 50 years. So
did you watch any of the operas that they're showing?
I've been watching a few.
Okay. Because my granddaughter and I, we sometimes sing a bit in the night together. I sing terribly, but she sings well. So we fool around a bit in the night at about 9:30, 10 o'clock, putting on the opera show and singing loudly
good.
to everyone's discomfort.
Very good. When do they expect the lockdown to be lifted in Calcutta?
I don't know whether it was an official notification I received, but I received something today that says there's going to be a 5-phase withdrawal. Each phase lasting 20 days.
But be careful. The thing that's going around on WhatsApp is fake.
Yeah. So that's why I said it's not confirmed.
Yeah.
So anyway, even that was fairly conservative in the sense that, look, they will allow some in the red zone, but they'll divide red zone into 3 categories, which again came in the newspapers today.
Yeah.
And in the first category will be very strict, second will be slightly looser, third a little more liberty. So that way, and after 20 days they review the situation and then add some more liberties. So they're talking about 100 day towards total removal.
Yeah.
Bombay, meanwhile, that just doesn't seem to be capping.
It's a very difficult situation. It's a very difficult situation. But I must say, both the state government and the center are doing an excellent job.
Yeah,
they're doing about as well as they can, I think, under the circumstances.
Yeah. Today, some announcements were made regarding some financial help for the SMEs, finally. So I think that's come as a bit of a relief. We have yet to go through the details, but it was very sorely required. Otherwise, there would be a frightening situation.
Yeah.
The larger corporates, of course, are well-heeled enough, but medium and small ones.
No. It's the medium and small ones that have to get going, because if you don't get that going, you will not generate enough demand for the larger businesses to sell to.
Correct. And also the supply chain. A lot of the small and medium supply the raw materials.
So you can't just sort of say one segment will start up and not anyone else. It has to be the entire economy that gets going.
That's right.
But then again, a very courageous decision to announce a lockdown, because it's not easy.
Yes.
It's not easy to shut down your country like that.
Yep. And I was very surprised. India took it pretty well. I was very impressed with our people, our citizenship.
Yeah. That's what I'm saying. Despite having perhaps the most difficulties in the world, they took it very well.
I think we're good to start. So we've got a good number of viewers on. Yeah.
Oh, great. So I'm starting off now.
Okay, go ahead.
Right. Ladies and gentlemen, welcome to this evening show. It's a very proud moment for us in the Calcutta Parsi Club to be able to introduce Darius Khambata, the senior counsel who practices before the Supreme Court and the Bombay High Court. A very distinguished gentleman. He did his LLB, the law degree, through the Government College in Mumbai. And then for his master's, went across to America and did it in the Harvard Law School. When he came back, he chose to intern under a very distinguished luminary, Iqbal Chagla. Darius, may I ask you to come in over here and tell us a little bit about your early years. What made you go towards this profession? Is it more or less a family occupation, or has it been unique on your part to go into this? And also a little bit about your years in law school and in college.
There is a family history in law. I must tell you, both my grandfathers were in law. One grandfather was a solicitor. He was a solicitor to the Tata Group. He was a partner, Mullah. The other grandfather was a judge and an ICS officer. My father was in law for a few years until he branched out into industry. So there is a family link to law. But quite frankly, I went into it by default because I really didn't know what to do. And even when I was in government law college, I could well have gone into accountancy or management or anything else that was available at that time. I think I really decided that law was a profession for me after I went to Harvard, which is surprising. But it's really when I was there that I realized what practice of law really was. And that's when things cemented in. And then when I came back, I was fortunate enough to get a great senior, Iqbal Chagla, and to join a great chambers. I joined what we sort of call Chamber Number 1, which was formally started by Sir Jamsetji Kanga, who was the doyen of the bar for decades. And he was one of the greatest, if not the greatest lawyer that India has ever produced. And he had this huge chambers in the sense, not in terms of size, but in terms of people who were part of it. So starting from Sir Harilal Kanya, first Chief Justice of India, Kola, H.M. Sirvai, Palkhiwala, Karsetji Baba, Ajal Vimadalal, you had the works all in his chambers. And then, of course, they had their juniors. So Karsetji Baba's juniors were Fali Nariman, Soli Sorabji, Iqbal Chagla himself. My father was in his chambers for some time. So it sort of spread out that way. So it was really a big chamber in terms of numbers. When I look back on the two small rooms that we occupied, it seems horribly pokey and small. But actually, there were a huge number of people. Even his other junior, Kanga's junior, Marazban Mistry, had Chief Justice Sam Barucha, Justice Sam Varyava as his junior. So you had a vast number of very talented and very warm and nice people in chambers. It was like a family, really.
Oh, wonderful. Wonderful. As a matter of fact, I think two Parsi youngsters over there in Bombay who are from Calcutta also practicing law. One is young Rian Vatsha and the other is Sarah Marden. They've both sent in some questions. I'll read them out a little later.
Okay, sure.
But they're both practicing over there. Sure. They're both working. So now, when you came back, you did work for a while as the Additional Solicitor General of India. And you also worked as the, Advocate General of Maharashtra and the Additional Solicitor General of India. First came the Additional Solicitor General of India. Now, what was the difference in these two positions that you held, in the kind of work that you did? What did you feel were the major variations or differences?
Well, both are public law offices, and both are offices where you effectively work for the government. The Additional Solicitor Generalship is central government work. So in Bombay, at the Bombay High Court, there is only one Additional Solicitor General. So all the work of the central government goes to him. Of course, it's physically impossible for him to do that. So he has a panel of lawyers below him. And you can more or less choose the matters you want to do. unless someone from Delhi calls up and requests you to appear in a particular matter. But I found this for the central government and as ASG, there were lots of points of law to argue, constitutional challenges. So that was really interesting. As Advocate General of the state of Maharashtra, you have much more firefighting to do because you again represent the state and you're in court and there are things happening in the state and in Bombay, and you have to go and evince the view of the government. There are of course questions of law that also arise, and the trick really in both these offices is to appear not in every single matter and not necessarily in matters that grab you headlines, but to really develop the good matters, the difficult points where the government really needs to succeed. And you sort of save yourself for those matters and take up those matters. And one abiding principle that I always acted by, which is the constitutional position, is that you are ultimately not a lawyer for that particular government. You are a lawyer for the Union of India or for the state of Maharashtra. And if it means that the interests or the instructions of the particular incumbent diverge from the interests of the state, then it's your duty to act in the interests of the state. And that does happen sometimes. And the quicker and earlier and more strongly you make that position known, the easier your life is in these positions.
So you yourself must have encountered some such cases or some such times, I presume.
There are. I dare say I'd be less than candid if I didn't say I got tremendous support on both sides, from the central government. And at one point of time, Salman Khurshid was the law minister, so I have a good relationship with him and he was very supportive. In Maharashtra, I was blessed by having Prithviraj Chauhan, absolute uncut diamond, as chief minister. And of course, there were several very distinguished IAS officers who I'm still in touch with, some of them. It's very reassuring actually to know that our government is in excellent hands for the most part. And the IAS is a tremendous service. Many of them could easily have been CEOs of large multinational corporations, etc., but they chose a life of service, and that's really tremendous.
Oh, wonderful. That's wonderful to hear, Darius. You have gone on record as saying that, if you do not believe in the matter, then you would not take up the case. And I guess that has proven your integrity. You're a man of great integrity and of values. Obviously, you're not willing to sacrifice your conscience on the altar of convenience. I think that's a wonderful trait. And I dare say it's a very Parsi trait. At least it's supposed to be. I think so. It's one of,
I hope so.
And it always has confused me, because lawyers tend to be treated as, not people of great moral fiber who will stand up for what is right, but rather will stand up for the client irrespective of good, bad, ugly, whatever, as long as, they get paid. I mean, that's the general impression. Then, of course, one does come across a few gems. So I think it's wonderful that you're here, Darius, talking to us and giving us a side that I think we have now grown too pessimistic to believe that there are good people in the government, there are good politicians, there are good bureaucrats. I think that's a very important message, particularly at this time when we need to get our faith reimposed in the country. Darius, there's a number of questions that I've got. But before we go into that, would you tell us something about this SX1?
All right, it's in England you have the old system, which we used to follow in Bombay and in Calcutta as well, and in Madras as well, of chambers. So council, we are not part of a law firm. We don't have a big swanky office with huge overheads and hundreds of interns and staff and masses of space and conference rooms and all that. So we are really counsel who are briefed by these firms to appear in court. We have rarely, if ever, any direct clientele. And we therefore used to, in the old days, sit in chambers. So we would share a couple of rooms or 3 rooms and share expenses. Now, in England, the system which has developed is that their chambers are huge. It's not just a few rooms. It's a building or 2 or 3 buildings. And they are large chambers. You could have 100, 200 lawyers as part of those chambers. They have a proper administrative office and setup. And they manage chambers. They manage all the work that comes into council. So usually these were the preserve only of English lawyers, but latterly they've been inviting lawyers from all over the world to join them, and they sort of select who they want. There are no commitments in the sense that I'm not bound to do the work that comes through those chambers, and but equally, it's a very pleasant atmosphere. You have good work from there, and as and when I have to work in either London or Singapore, I have the benefit of using their facilities. Oh. It's really very good people in that chamber, and therefore I'm really glad to have joined it.
Oh, wonderful. So it's by invitation. And
it is. It is, yeah.
Well, that's good. I also read, and you never did mention, I guess you are too modest to mention, that when you ended your term as the Advocate General of Maharashtra, you were accorded the highest appreciation for the meritorious service, a meritorious and distinguished service by the government. Can you tell us something about that?
I'm sure they do it for everyone, but what particularly pleased me about that was, and this doesn't often come through, but that was a resolution passed by the new government, not by the government that had appointed me. It was by the successor government who took over. And I was very pleased that they were praiseworthy, and I think they also appreciated that I had taken a balanced stand in certain matters during my tenure.
Wow! So appreciation from politicians on the other side too. Wonderful, wonderful. Sure. You're also a member of the Securities Exchange Board of India, otherwise known as SEBI. And
I'm not a member of SEBI. I'm not a member. I'm a member of their Takeover Panel.
Oh, I'm sorry. It was written that you are a member of.
No. I'm not a member of SEBI.
So you're a member. Oh, currently a member of SEBI's Takeover Panel. That's right. Okay. And you had made some recommendations for insider trading. Could you give us some idea of what this is about?
Actually, the two things are totally different. A few years ago, SEBI, as an institution, wanted to take a fresh look at its insider trading regulations. So it appointed a committee. It was under the chairmanship of retired Justice Sodhi. He was an excellent judge, an excellent human being. He was formerly Chief Justice of Karnataka. And then he sat for about 5 years as chairman of the Securities Appellate Tribunal in Bombay. So they appointed him chairman. They appointed a fairly wide committee of lawyers, of stockbrokers, investors, businessmen, even a journalist was on the committee to recommend what they wanted. They wanted a balanced, fair insider trading laws. So they set us up and we had several meetings and we came up with many suggestions. I think most of them were accepted. And the insider trading regulations were completely revamped at that stage. So that was the committee. And the Takeover Panel is something quite different, actually. It's something I'm on currently. It's a small panel of, I think, 5 of us. And again, that happens to be chaired by Justice Sodhi. And there, what we do is we give, in certain deserving cases, we give exemptions from the rigors of the takeover regulations if we think that in substance, the application is entitled to it, but it's only by virtue of a technicality that they've got enmeshed in a requirement to make an open offer. So that's a different sort of thing.
Oh, okay. May I, with your permission, go on to some of the questions that people have asked? Right?
Certainly.
Great. During this lockdown time, we've got a number of messages from Reliance. Everybody's got people who have contracts with them, citing force majeure clause, saying that the contract is not.
I have to stop you right here. I can't answer those questions. I'd be conflicted.
Okay.
I can't.
Oh, all right.
Yeah.
Okay. I had no idea. My apologies. Then let's move on to the Parsi element. We know that you're a fairly religious person, and that you have studied our scriptures, and that you have studied law obviously, and that you had brought up at a meeting once, saying that there is nothing exclusive in the religion which precludes or which keeps women out. It is neither in the religion nor in law that we are keeping out the children of women, Parsi women who marry non-Parsis. So could we have your thoughts on the matter, both from the religious aspect as well as from the legal aspect?
Sure. Let me start with a firm disclaimer. I am not an expert on the Zoroastrian religion. I don't profess to be. And I think the religion must be left to the experts in the religion. So that's very important, because sometimes these lines are crossed. Okay. What I know about the religion is from books, and I think very careful when I cite a principle or a proposition to ensure that it is grounded in some good, acceptable source, some reputable source. Okay. Of course, there are issues of interpretation, and that only the experts really will be able to tell us. I have read a bit about the law surrounding our community and who is considered to be a Parsi Zoroastrian. And there I think I may, as a lawyer, as indeed other lawyers also, have some competence on that aspect of the matter. And I am religious, but I am not overtly religious. So I do believe there is space for both types within our religion. I respect those who are overtly religious as well. They have their own approach to Ahura Mazda. But I believe there is so much in our religion, or at least what I've read of it, which encourages a modern approach, an objective approach, an approach where, for example, in the 30th Yasna, each man should choose for himself, man by man, and decide for himself what to do. And Ahura Mazda only assists you in that choice. It's your urvan, your free will. So if you read books, a very simple book to read, for example, currently available is Justice Rohington Nariman's book on the Gathas. Simply written, very clearly written. You can understand a lot about our religion. Mary Boyce's books are superb, including her basic books. So there is enough easy reading material. When I speak on the rights of Zoroastrian women who have been married outside, I'm largely drawing from the famous Parsi Panchayat case, the 1910 judgment of Justice Dava and Justice Beeman. And that case was an interesting case where, I don't know if most people know this, it really involved Suni Tata, the mother of J.R.D. Tata, who was a French lady, Suzanne Brière, and she had married R.D. Tata. And just hours before she got married, a Naujot was performed by 60, mark you, 60 priests. Including, I think, a Vara Dastur. And she did her Naujot, and then shortly afterwards was married according to Zoroastrian rites. So far, so good. But a couple of years later, she tried to enter the Bandra Parsi Agyari, and she was stopped. Now, she actually took no action. This is very interesting. She took no action. But Sir Dinshaw Pittit, who I think was related to them and also a very close friend, filed an action or proceeding before the Bombay High Court against the Parsi Panchayat. So the whole matter proceeded on the action of someone who was not directly concerned. And in those days, laws of standing or locus standi were far stricter than they are today. So the whole matter was gone into at his cause. Extensive evidence was led, 50 or 60 witnesses. And the finding of the division bench is that ultimately all the witnesses admitted, those in favor of the plaintiff and those even who initially came to give evidence to support the position of the defendants, all of them ultimately admitted, whether in chief or in cross, that Zoroastrianism was a proselytizing religion. Not only did it allow, but it enjoined conversion. It was a universal religion to that extent. However, they also found on evidence that since our advent into India, there was not one single proven case of conversion. This is very important. So they found a practice that had developed of not converting. And then came the vexed issue as to who was a Parsi Zoroastrian. And this arose because you were considering trust deeds of various trusts set up by individual Parsis over time, which were in favor of the my community or the Parsi Qaum or the Parsi community or Parsi Zoroastrians. And they had to really enter the minds of these settlers. So what they said was that we have to see what the settlers intended by those terms. And Justice Davar then came to this formulation that what the settlers must have intended was the beneficiaries are restricted to 3 classes. The first is someone born of the descendants of the original Parsis and whose parents were both Parsi Zoroastrians. The second was the class of Iranis who had fled from Persia. As you know, they were being persecuted.
Yes.
So towards the end of the 19th century and into the early part of the 20th century, there was a whole set of refugees from Iran who came. So they were the second class. They were all Zoroastrians. And the third category, he said, were the children of Parsi Zoroastrian fathers who had intermarried non-Parsi or non-Zoroastrian wives. So therefore, classic case, R.D. Tata himself, his son J.R.D. was born of a non-Parsi mother. Now the question is, why only fathers? Why not mothers? And the second judge, Justice Beeman, who I must tell you was a junior judge, he was, today you would call it visually challenged. He was actually someone who couldn't see, but he was a good judge. And he actually in his judgment says that the third is nothing but what he calls pure Oriental caste, because caste also goes through the father. So this was the formulation, or I would say the compromise that was reached, because the Samast Anjuman before that actually had passed a resolution saying no children of intermarriage should be permitted. So the entire inquiry was really as to who are entitled to become beneficiaries of these trusts. It was a legal question. But in the process of that legal question, a lot of evidence was taken on the religion itself, and the finding was that the religion did not prohibit conversion. So with this in mind, then you of course go to your next case. I'm sure your listeners are aware of Saklat and Bela, which is the Privy Council, which reaffirmed the findings in the Parsi Panchayat case. And actually came up with a very nice compromise at the end, which is unique. Lord Phillimore said this. He said, no doubt, these are the 3 categories. However, as a principle of trust law, if you can allow a non-beneficiary to use trust property in such a way as not to deny a beneficiary any vestige of his right, then nothing stops trustees from allowing that. So in other words, obviously, if it is property, housing, medical, you can't allow a non-beneficiary, because there will be, to that extent, the corpus or the availability of resource of the trust will be reduced. But if you can allow use of property, say if it is a garden, or I would say even an agyari, if you allow children of a Parsi Zoroastrian mother married outside into the fire temple, as long as you are certain that the religion does not proscribe it, and the religion they found on evidence, there was no evidence that that was proscribed by the religion, he said there was nothing to stop trustees from allowing this. They would not be in breach of trust. So that's the balance that was reached. Now, of course,
they will not be in breach of trust. So they may allow it.
At their discretion. But there's no entitlement or right. There's no entitlement or right. Okay. Now, this is in a pre-constitution setup. Post-constitution, the point has not been tested. And I don't want to really speak much on that because there are cases that are sub judice. So that in a post-constitutional matrix, how a court will approach this issue is an open question. But I want to say one more thing.
Yes.
I really believe that we shouldn't see this purely as a legal issue. It would be folly to see it as a legal issue, because we are now a small community. We are told that we are a dying community.
Yeah.
I don't entirely buy that, but the numbers sometimes don't lie. It's time that we, of our own, without forcing a matter to court, took a broader and more inclusive view. It's not that by permitting a few children, many of whom really believe more powerfully and zealously in our religion than many Zoroastrians themselves, Parsi Zoroastrians themselves, to allow them into Agyaris to worship our religion, I don't see how that can detract and how that can dilute our religion. It can only strengthen it. And it can strengthen us as a community if we are more inclusive. And I want to talk about this later if we have time, about what we should really be doing in the years to come, instead of getting diverted into all these controversies and fights. I know everyone feels strongly, and they bona fide feel strongly. I respect everyone's view. The Orthodox, they have great faith, and I completely respect them for that. But it's time now everyone met and came to a compromise and did it voluntarily rather than forcing a court to decide. That's what I feel.
I see. See, we ourselves are in such a situation here in Calcutta, but both sides we are pretty amiable towards each other and wanting to get a verdict from the court. But 30 dates have come and gone and nothing has happened, nothing has moved in the court. So if you're in a situation, where it seems the legal system is just not geared up to meet our request or our requirement of hearing the matter. I just wanted to belabor one point, if you would pardon me. If the trustees were to allow a child of a Parsi, non-Parsi father into trust, nobody could then file a case against the trustees. Is that assumption right?
As I said, this is a matter that's sub judice, and it would not be correct for me to get into that issue.
It is already in court, is it?
That's right. So it would not be correct.
Okay. All right. Thank you. Thank you for that. Now, so in the course of your experiences as a senior lawyer, you must have come across an unreasonable judgment or a judgment you felt was not correct, especially in a sensitive case where you feel that you have been hard done by. How do you manage? How do you cope with the situation?
I'll come to that. I have one more thing to say on the earlier issue, if you don't mind.
Sure, please.
And this is very relevant because sometimes one gets mischaracterized. The policy against conversion, which we have followed since our advent into India, is a wise policy. And I don't think we should abandon it. It really matters not whether the religion permits it or enjoins it. I think as a minority in otherwise such a welcoming country like India, and we are all Indians first, of course, I think conversion is a no-no. It's completely the wrong way to go. So whatever I say, and including when I speak of the universality of Zoroastrianism, that is directed only towards the position that we must now accept children even from intermarriages where the mother is a Parsi and not the father, because it is discriminatory to accept the father's children and not the mother's children. So I think we should move or reform in small steps, and I would take this small step for the moment. I don't think conversion should be on the table at all. It would be retrograde. But coming to what you said, yes, of course, one always feels disappointed in matters where you feel you should have won and you don't. But you are also chastened by the fact that there are matters in which in your heart of hearts you feel you should have lost and you won. So, it's always better. It's always better, as one senior lawyer said, not to celebrate your victories too much, because you will also have defeats. That's part of the game. There's no point in trumpeting your victories here.
Very correct on this. Quite right. So if we go on to perhaps another question, which Khurshid Vacha asks, Khurshid Adeshar Vacha, she's very particular. Are our fundamental rights as citizens absolute and guaranteed? And if that is so, then how do we explain the writings in the NSA and the Unlawful Activities Prevention Act?
No, the answer is simple. Your fundamental rights are not absolute and unrestricted. It depends on which fundamental rights you're talking about, but there are different restrictions on different rights. For example, your fundamental freedoms under Article 19 are expressly subject to reasonable restrictions. And there are, depending on the freedom concerned, there are heads of reasonable restriction to which they are subject. So, for example, freedom of speech is subject to 8 categories of reasonable restrictions, which could include the sovereignty of India, security, public order, 8 such heads. So therefore, our scheme of fundamental freedoms is different, for example, than the US Constitution, where, for example, right to free speech is textually absolute and unlimited, though there have been judge-made exceptions to that. Ours is a different kind of constitution, though still giving a lot of space for fundamental freedoms and fundamental rights.
What would you feel is the major differences between perhaps the American law and the Indian law? We are both, I presume, based on the British system. But what would be the major differences?
Oh, the American law started in common law, but it very quickly branched out into its own unique brand of common law. So the American law in various fields is far removed from British law, especially their constitutional law, because they have a written constitution, as you know, and their Bill of Rights, etc., have gone far beyond UK law. UK has a constitution, although unwritten. It's based on convention and law. Okay. So it's a different kind of common law, rather in the way that common law is developing in India in a different kind of way.
Okay. And this one, I mean, all of us wonder as to the right to bear arms, which all Americans, so stoutly defend.
The Second Amendment.
I guess it's really, it's befuddling. Why are they so crazy about, wanting to carry handguns and weapons all over the place?
Well, the American Constitution finds a lot of its beliefs from their own war of independence. And at that time, the right to bear arms was something very important, because it was precisely that right which was taken away by the British. So it was one of the freedoms that they wanted. But a constitution is a living, breathing document. This is sometimes the mistake we make here. We try to put every last detail into the constitution. That's the wrong way to go. A constitution should set out principles, aims, aspirations, and certain broad limits, which is what the US Constitution does. And then in a common law country, that is usually left to courts to interpret over the decades. And obviously interpretations will change depending on the current mores, the view of the times, modernity, which is exactly how a constitution has to be. It has to be flexible. So what was true of the Second Amendment when it was made, that situation may no longer be true, and the Americans have to sort this out. But today they do have the right to bear arms engrafted upon their constitution. Questions will always be, is that an unrestricted right? For example, the First Amendment. The First Amendment says Congress shall make no law that abridges free speech. But indeed it can and has made laws that abridges free speech in certain select areas, like an incitement to secession, like in the judge-made law of the famous formulation of Justice Oliver Wendell Holmes, falsely shouting fire in a crowded theater. That's not protected by free speech. So there are areas where, though the Constitution purports to give an unrestricted right, indeed that is always restricted. So Holmes, sorry, can you hear me? Yeah, can you hear me?
I think his connection might have frozen.
Yeah, no, I can hear you guys now. I can hear you. Can you hear me?
I can hear you, but I think Numi Uncle's connection is.
Oh, I see. Okay.
Frozen.
Oh dear.
What I can do is.
How has this lockdown affected you all?
Sorry?
Numi Uncle, I think you were frozen for the last 30 seconds. Can you just repeat the last question? Yeah.
Okay, so sorry. One more question, right? How has the lockdown affected you?
Well, I think it's affected me like it's affected most people. We've we've had time to introspect. We've had time to reflect.
Of approaching your profession.
And rejuvenate. We have to reinvent ourselves as professionals. So as I said, I was talking to you earlier, we are now learning the skills of remote hearings, how to argue from e-briefs, how to have an entire hearing with the lawyers, judges, all located in remote locations. Sometimes even the staff and the stenographers are separate, the clients are separate. So it's difficult, but it's a skill we will all have to learn and perfect, because I foresee this situation continuing for several months. Have we lost Numi again?
Yep, it seems so.
Okay.
Should I ask you another question till we
sure.
return?
Yeah.
Okay. There's a question from Rian Vacha, who asks, in the light of the current scenario, Uttar Pradesh has recently introduced an ordinance accepting companies from the purview of most labor laws. How would this affect the laborers and workmen in the event of any industrial dispute?
That is a very controversial step, because on the one hand, there's no doubt that we have allowed a plethora of labor laws and industrial dispute laws to develop and grow over the years. And it's got into almost unmanageable proportions. So it's very difficult for an industrialist to really set up and operate a factory without all sorts of commitments and obligations. And there's a crying need to rationalize, streamline, and now, distill all this into one or two laws. But that said, a blanket embargo on their operation might not be in the best public interest, because you have a situation where many of these laborers are living hand to mouth. This is their insurance and their security. There is no other security blanket. And to, in one fell swoop, by the stroke of a pen, just take that away from them is a very far-reaching step. And I'm not sure that it's really going to work out in the public interest. The thinking is, the rationale is, we have plenary powers under the Disaster Management Act or under the Epidemic Diseases Act to do all this. But I don't believe those powers can ever be plenary. I mean, your classic example of this is the great dissent of Lord Atkin and Liversidge and Anderson, where 4 judges of the House of Lords in 1942, at the height of World War II, upheld an uncontrolled power of imprisonment given to the Secretary of State, Home Secretary. And Lord Atkin said nothing of the sort. Amid the clash of arms, must the law be silent? And he said, I cannot give a strained interpretation to these words, which my brothers have given. Whether in war or peace, the laws must speak the same way. And that's a very important principle we must understand. So whereas streamlining labor laws is the way forward, it had to have been done over these last decades. This might not be the correct approach.
I'll move on to a question from Shara Madden, who's also a lawyer. And she asks, the general sentiment towards the Citizenship Amendment Act is that it targets a particular minority. Do you think that it's possible that the next step of the legislation may affect other minorities in the country as well?
Well, let me answer your second question first. I don't think so. The Citizenship Amendment Act is, of course, a very controversial matter. I think the correct way to approach it is not, again, purely legalistically, or is it constitutional or not? Because there will be arguments both ways. There are strong arguments to say it's discriminatory. There are strong arguments to say that when you have narrowly tailored an object, you can sustain an act like this. I think the correct question to ask is it wise? Is it necessary? And to my mind, it's not. At this point of time, when we need to be unified, it's not wise to reopen these sort of fissures. To what purpose? The same result could be achieved by a simple provision that any person who is persecuted in any neighboring country is entitled to fast-track citizenship of India. That's all you had to do. So is it really wise to have taken this path is the question I pose.
I think Nomiansal is back. I can slip in another question while he's getting his audio set up.
Yes, yes, go ahead.
There's a question that's coming from one of our viewers right now, that's Srinaz Mugrelia, on the topic that was being discussed earlier. And she asks, how far down the line would you go in accepting children of a Parsi Zoroastrian parent?
Well, my starting point is the Parsi Panchayat case. Ninsha Manekji Petit and Jamsetji Jibai. And if that bench, after hearing extensive evidence, went so far as to accept the children of a Parsi father, a non-Parsi mother, I think in the post-constitutional environment where this would clearly be seen as discriminatory, I would certainly say that children of non-Parsi fathers but Parsi mothers should be equally accepted.
Hi, Darius, I'm back.
Yep.
Sorry,
Hi,
the Wi-Fi went on the blink.
Yeah.
Wi-Fi went on the blink, so I've switched to my connection. We've got a question here from Yazdi Karai, who says the Uniform Civil Code is an ongoing point of debate regarding the Indian constitutional mandate to replace personal laws. Article 44 lists the Uniform Civil Code as one of the directive principles of state policy. He says, I believe that there can be no gender equality unless India adopts the Uniform Civil Code. What is holding this up? And how can like-minded citizens make this implementation possible?
Well, I think the Uniform Civil Code, as you said, is part of the directive principles, which are not binding, but which are aspirations that the state must aspire to. Supreme Court has repeatedly commented on why this is being held up and it should now be sought to be implemented. I think there are two aspects to it. The fact that you must have a Uniform Civil Code, I think is, in my way of thinking, is unobjectionable. That is a dream that we must aspire to. But I don't think enough attention has been paid to what the content of that civil code must be. It's simple enough to say you must have a Uniform Civil Code, and I am strongly in favor of that. But I don't think enough work has been done to put down what that code will say. What personal laws will apply? How will they apply? I think a little more work needs to be done on that. And ultimately, I think all Indians must realize that religion has to be a private thing. Religion is a private matter, and our constitution protects our right to administer our religious affairs, to have freedom of religion. But the Article 26 right, as we know, is subject to public order, health, and morality. So there will be certain practices that will be filtered out as pernicious by a Uniform Civil Code. So I would leave it at that. I think the way to go forward is not to impose it, but it's to persuade the vast populations who are opposing it that their opposition and their fear is unfounded. So unless you make them feel secure, and that can be in a variety of ways, you're going to have opposition from large sections of the population.
So we've got a question from Shara Madan, who asks about the Arogya Setu app and the accompanying privacy issues which are there. So what are your views on the privacy issues, and how far and how should they be protected?
See, there again, the government has plenary powers at a time of such pandemic. From the time of the Epidemic Diseases Act of 1897, which was enacted to counter the plague, right to the Disaster Management Act of 2005. They can take any measures, and therefore that is thought of as plenary. But of course, in a constitutional democracy governed by common law and by rule of law, no power can be plenary. It always has to confine itself to certain other standards and objectives, including freedoms, and one will be the right to privacy. This is the balance that has to be struck. And the right to privacy judgment lays down the test for striking this balance. Is it of such compelling necessity that you need to intrude on the privacy of individuals? Then the answer is the law will be upheld. So it's that sort of a balance that has to be justified. I would have thought that if the privacy of individuals is going to be affected, because some people say that it can track your movements, etc., then it might have been better brought in via statute law, which could be enacted, rather than just as a measure under one of these acts. But it all depends on what safeguards are introduced, whether the safeguards are enough to guard your privacy, or whether they allow effectively by the back door a complete intrusion into your privacy.
Okay, sir. This minorities, the citizen, I don't know, have I brought this issue up before, sir? The Citizenship Amendment Act?
I was asked this, yes. When you were off, I think, yeah.
Okay, then I guess we've covered almost all the questions we've got, except for the last one by Shara, who asks, is it advisable to do the master's degree after the LLB degree? What would be your recommendation?
Certainly. Particularly in America, I think it would be a great career move. And in fact, I just want to wind up by saying one thing, that I hope this pandemic makes better Indians of us and better Parsis. And one of the areas I think that we as a community have to look at is, in fact, education. We have the resources, and this is one area where the fact that we are a small community is actually an advantage. It's something we can leverage. So if we act with unity, get our community resources together, set up educational institutions even in India, so that she doesn't have to go to America. You have a top-class institution in India, which can be a minority institution and therefore with reserved seats for Parsis. If we can build up our network of Parsis to give jobs, internships, etc., I think that's the way to go forward. But yes, if specifically, please go to America. You'll have a ball. It's a great thing to do.
No. Well, I don't know in this pandemic when it's going to allow foreign travel and when people will be comfortable to leave the shores. I guess there will be a new way of, perhaps there'll be a new way of teaching and learning too, which might require you to spend some more time here and perhaps
I'm sure they will. I'm sure they will. But we've always adapted as a community, and we'll adapt here as well.
Yes, I'm sure we will. Darius, it's been absolutely fantastic having you. You've come across as a very warm, very genuine person who cares for the community. And may I ask you to say a few words on the community itself, perhaps as far as the inclusiveness goes, which I know is a topic dear to your heart.
I think, as I said earlier, I would love to see the community come together and sort out its differences across the table. I would love the community to be more tolerant of different points of view, to respect divergent points of view, to discuss them rather than be scared to discuss controversial matters, to respect of the freedom of speech of people who have differing point of views, and to try and reach some compromise that can then take us forward as a community rather than this constant fight on issues that have been burning for so many decades. It's really wasting away the strength of our community. Instead, we should focus on our youth. We should have a liberal, open, inclusive atmosphere. We should focus our resources towards education. To my mind, that's the key. That's the game changer. And I think I don't have a pessimistic view of the future of our community if we adopt that course. But this constant bickering really has to stop. Let's each of us take a pledge to step back, to let the other person to win the argument. Let the other person win the argument, no problem. I think when we learn that quality, we will go forward.
Well, sir, I might mention that in Calcutta, we have gone quite a long way towards that. We have a very small community, just 400 plus, but we are fairly united and we are fairly tolerant of each other. We enjoy each other's company. And I dare say there'll be, we have 400 people over here, but one of our programs were watched by as many as 10,000 people. So I guess friends and relatives from across the world watch these programs. And we're very happy that we had a chance to interact. And you know, this pandemic has actually brought us closer in a way, because we are in each other's homes now. for at least an hour, hour and a half each evening, very often with somebody who gives us cause for inspiration, or as the program is called by Parsi Club, aspire to inspire or inspire to aspire. I'm not very sure.
So let me say one more thing. Let me say one more thing which is of interest. Let's give ourselves a Parthian shot. You know the expression in English, parting shot?
Yes.
It actually comes from the Parthian dynasty, which was a Zoroastrian dynasty in between the Achaemenian and the Sasanian dynasties. And their riders were very adept at riding and at the bow and arrow. And they had specialized in, while they were retreating on full gallop, they could turn round and in the opposite direction suddenly surprise the enemy by letting loose a hail of arrows, which became known as the Parthian shot. Hence the English expression parting shot. So as a parting shot, even if we have to die out, let's go out in glory. Let's not go out in a bickering manner.
That's very true, very true. We have a proud legacy, and I think it's a legacy that needs to be protected. And more importantly, the values need to be protected, perhaps much more than anything else.
Absolutely.
Thank you, Darius.
Thank you.
We find most of these qualities in you. As you mentioned, we do find you to be a person of great integrity, great frankness, and may I say, a very gentle, charming way of talking. Thank you so much, Darius.
Thank you, Nomi. Thanks to everyone. Thanks for listening.
Ratan, over to you, my friend.